Good afternoon, everyone, and welcome to the 52nd Annual Zuber Moot competition. My name is Sabrina Ferreira, and I, along with Mario Bottoni, Julia Champa, Samuel Lawrence, and Campbell Wackerlin, are the 2025 Zuber Moot Committee. We would like to welcome all of you and our distinguished guests. Our final round bench, Justice Carrozza, Justice Ramon, Justice Caricia, the Honorable Dr. McMurtry, President and Vice Chancellor of the University of Windsor, Rhonda St. John, Executive Assistant to the President and Vice Chancellor of Windsor, Dean Reimbadi of the Faculty of Law, David Zuber and family, Associates of Zuber and Company, LLP, faculty members, law students, and all esteemed guests joining us today. The Zuber Moot is a student-run internal mooting competition at Windsor Law that offers upper year students the opportunity to strengthen their written and oral advocacy skills. It encourages a deeper engagement with legal principles while fostering an understanding of appellant advocacy. The Thomas G. Zuber Competition Trophy proudly displays the names of the 4 finalists who have competed each year for the last 51 years at Windsor Law. The engraved names on the trophy stand as a lasting testament to the esteemed legacy and tradition of the Zuber Moot appellant advocacy. Campbell Wackerlin will deliver the land acknowledgement.
Good afternoon, everyone. Thank you so much for being here with us today. Before we begin, we acknowledge that the University of Windsor sits on the traditional territory of the Three Fires Confederacy of First Nations, which includes the Ojibwe, the Odawa, and the Potawatomi. We respect the long-standing relationship with the First Nations people in this place, in the 100-mile Windsor-Essex Peninsula and the Straits, les Détroits of Detroit.
So first, we'd like to introduce our incredible panel here tonight. It's my pleasure to first introduce Justice Steve Carrozza. Justice Carrozza was appointed to the Court of Appeal of Ontario in April 2020. Before being appointed to the court, he served as a judge with the Ontario Court of Justice in St. Catharines from 2009 to 2013, and with the Superior Court of Justice in Brampton from 2013 to 2020. Prior to his appointments, Justice Carrozza received an LLB from the University of Windsor and was admitted to the Bar of Ontario in 1997. He also received an LLM from Osgoode Hall Law School in 2003. Justice Carrozza was a staff duty counsel for Ontario Legal Aid in Toronto from 1997 to 98, and from 98 to 2009, he was senior counsel with the Department of Justice and Public Prosecution Services of Canada, where his main area of practice was criminal law. He was an adjunct professor of trial advocacy at Osgoode Hall Law School from 2010 to 2015. And in addition to his role as an adjunct instructor with the Trial Advocacy Seminar, Justice Carrozza is an instructor with the Intensive Trial Advocacy Workshop at Osgoode, and a guest instructor with the University of Notre Dame Trial Advocacy Program. At the October 10th, 2023 call to the bar ceremony in Toronto, the Law Society conferred Justice Carrozza a degree of Doctor of Laws. We are deeply honored to have Justice Steve Carrozza with us here tonight. Thank you.
It is my great pleasure to introduce Justice Moise Ramon for his inaugural appearance as a presiding justice at Windsor Law's Zuber Moot Competition 2025. Justice Ramon graduated with a Bachelor of Arts from the University of Prince Edward Island in 1993 and an LLB from Osgoode Hall Law School in 1996. He was called to the Ontario Bar in 1998 and spent over 18 years working as Crown Counsel with the Department of Justice and the Public Prosecution Service of Canada. In April 2016, he left the Department of Justice to work as counsel at the Ontario Ministry of the Attorney General's Crown Law Office Criminal Division. In December 2016, he was appointed to the Ontario Court of Justice, where he served for 5.5 years until his appointment to the Superior Court of Justice in June 2022. He was elevated to the Court of Appeal of Ontario in March 2025. For much of his legal career, Justice Ramon has taught trial advocacy and mentored lawyers and law students. He has been teaching trial advocacy at various programs since 2003, including Osgoode Hall Law School's Intensive Trial Advocacy Workshop for Lawyers and the Trial Advocacy course for upper year law students. He has also taught trial advocacy to law students at the University of Notre Dame's Intensive Trial Advocacy Workshop. As a lawyer, he was a mentor at Osgoode Hall Law School's Mentor Program, and in 2013, he received the Mentor of the Year Award from Osgoode's Alumni Association. We are excited to welcome Justice Moise Rahman.
Good afternoon, everyone. It is my great pleasure to introduce Justice Maria V. Caracia, a distinguished member of our local bench whose career exemplifies dedication, integrity, and service. Justice Caracia was born and raised in Windsor, Ontario. She attended the University of Windsor and received an honors BA in English Language and Literature. She attended the University of Windsor Faculty of Law and graduated in 1987. Justice Caracia was called to the Bar of Ontario in 1989 and practiced exclusively in the area of criminal defense for 31 years, both as a sole practitioner and in association with other lawyers. She was the past president of the Windsor-Essex Criminal Lawyers Association. Justice Caracia was appointed a justice of the Superior Court of Justice in Windsor on June 1st, 2020, and is a sessional instructor at the Faculty of Law, teaching criminal trial advocacy. Justice Caracia's accomplishments reflect an admirable career devoted to advocacy, mentorship, and service. As a distinguished woman in the judiciary, she is an inspiring figure for our law school community and for future members of the profession. We are very honored to welcome Justice Caracia to this year's final round. This year's Zuber Moot final round is very special to Windsor Law, as we remember and honor the Honorable Justice Thomas G. Zuber, the founder of this Zuber Moot competition. We are very pleased to have the Zuber family members with us today. At this time, we would like to invite Dean Ream-Body to provide remarks.
Thank you. It is my pleasure and privilege to welcome everyone to the 52nd Zuber Moot competition and to say a few words of thanks and congratulations to some special people. First, a special welcome to David Zuber, to family members, to colleagues, and to friends of the Zuber family and Zuber and Company LLP. I would be remiss if I didn't say thank you for sponsoring our reception earlier today. David, I think you and I met 2 years ago at the 50th Zuber celebrations, and we've had a couple of conversations since then. And I have to tell you, I've not left a single conversation with you where I haven't felt inspired in some way. And it's a deep honor to be able to pay tribute to your father today, and I look forward to your remarks later in the agenda. Thank you for being here. Special thank you also to President J.J. McMurtry. It's not often that we have the privilege of a president who takes time out of his very busy schedule to be with us. So on behalf of the entire Windsor Law community, we say thank you. And if you have to leave, we understand. I think this is the first time in my time at Windsor Law that we've had our university president here. So thank you very much. To our esteemed panel of judges, Windsor Law alum Justice Carrozza and Justice Caracia, and our first-time Zuber panelist, Justice Rahman. We know that you've made significant efforts to be here today. It's greatly appreciated. And also appreciated are your wisdom, your expertise, and your dedication to legal education. So thank you. I also would like to extend my thanks to Professors Curis and Little Kwan, who are somewhere surely in this room. There they are. Thank you very much. You've been coaching and mentoring the Zuber teams for decades. We tried to figure out how many decades before we started, and no one knows the answer, but several decades. So thank you. and to Melanie Monmini, who is right there, who very quietly and diligently has been working in the background to support our students. The Zuber Moot represents the very best of Windsor law. The entire Zuber undertaking, from the day-to-day organizing, the agenda setting, the communications, the logistics, the choosing of cases, and the shepherding of over 100 students from the preliminary rounds to today's final round, all of it has been carefully undertaken by the 2025 Zuber Committee. So Sabrina, Mario, Julia, Campbell, thank you very much. Samuel, Samuel, can never forget Samuel, thank you very much. You are all individually and collectively special and powerful people, and thank you for everything that you do. Congratulations to our 4 finalists who are waiting anxiously to get this started and hoping that we actually don't get started. I know that feeling. You have emerged as finalists in this competition, and we're so proud of you for that. But we're also proud of you because the finalists also agreed to take on next year's competition. I hope someone told you that. And we're proud of you for carrying on that Windsor law tradition, so thank you. This year saw the largest number of students compete, and congratulations to all of you who participated, because no matter where you landed, the Zuber competition could not have been possible without you. I hope you learned from it, and I hope that you enjoyed it. As I noted earlier, the Zuber Moot represents the very best of Windsor law. It's fierce competition wrapped up in camaraderie and mutual support. You don't get that very often, but it is Windsor law. And the skills that you'll see on display today, collaboration, deep thinking, careful preparation, analysis built on factual inquiry, the ability to organize and inspire people, and the desire to communicate with others to resolve social problems. These are skills that are needed in law schools, but also in society. So today represents a month of skill building and community effort, and I'm proud and honored to welcome you all to the 52nd Zuber Moot, and excited to turn the podium back to the 2025 committee to get us started. Thank you very much.
All right, thank you, Dean Boddy, for those truly wonderful remarks. Just a little bit of housekeeping before we get going. First, we'd ask you all to turn your phones off if you haven't already. Secondly, after the moot concludes, the judges are going to exit for a period of deliberation. During that time, we're going to give out a few awards, and then finally the judges will return and render their final decision. So, without further ado, we have 4 incredibly talented students here to argue for you. So, sit back and enjoy the show.
right, good afternoon. We have one case on our docket this afternoon. The Government of Saskatchewan Attorney General for Saskatchewan and John Howard Society of Saskatchewan. Counsel for the appellant, Taylor McAuliffe, Kayla Zikic. Counsel for the respondent, Jordan Yordanov, and Makar Tulloch. All right, you've each been allotted, I think, 15 minutes of time. We have read the materials. We're well briefed on the factual background. So I don't know who's leading off for the appellant. You can get right into it, okay?
Good afternoon, Chief Justice, Justices. My name is Taylor McAuliffe, and I appear alongside my co-counsel, Kayla Zikic, on behalf of the appellant, the Attorney General of Saskatchewan. The appeal before the court today lies in Section 68 of Saskatchewan's Correctional Services Regulation. This section outlines that the burden of proof for disciplinary offenses is on a balance of probabilities. In striking down Section 68, the Supreme Court has blurred the line between criminal prosecution and administrative discipline. I will begin by addressing the first issue on appeal, that the Supreme Court erred in finding that Section 11 was infringed by Section 68, and my co-counsel will then address the appellant's submissions regarding Section 7. The Supreme Court's approach undermines both safety within prison walls and the constitutional boundaries that Section 11D is designed to protect. Upholding Section 68 affirms that fairness and discipline can coexist within institutional walls, and that prisons retain the ability to ensure safety without turning every disciplinary decision into a criminal trial.
Well, are we talking about every disciplinary decision, or are we realistically talking about, ultimately, you can tell me and point me to it, what the evidence shows, disciplinary decisions that have far-reaching consequences, such as segregation or loss remission?
Yes, Justice. Today we're talking about disciplinary decisions that are under the major disciplinary issues within Saskatchewan's correctional facilities, and the sanctions specifically that I will be addressing are loss of remission and segregation. Turning to the first issue on appeal, I will be making two submissions. First, that the threshold for overturning the Queen and Shubley has not been met. And second, that applying the two-step test from the Queen and Wigglesworth confirms that Section 11 does not apply to Saskatchewan's administrative disciplinary proceedings. I will now turn to the first submission, which begins at paragraph 9 of the appellant's factum. The appellant submits that the threshold for overturning the Queen and Shubley has not been met. The doctrine of stare decisis is a constitutional principle that underpins the rule of law. It ensures consistency, predictability, and stability in legal decision-making. This court must therefore begin by evaluating the legal standing of the Supreme Court's decision in Shubley. As Justice Karakatsanis most recently reaffirmed in the King and Edwards, precedents must stand unless shown to be unworkable or founded on eroded reasoning. Shubley is neither unworkable nor eroded. The framework established by Shubley continues to be applied effectively, and continues to affirm that disciplinary proceedings serve regulatory purposes and fall outside Section 11.
So just, can I sort of ultimately get your submission? Are you saying that it was not open to the Supreme Court of Canada to revisit Shubley in light of what? An erosion? I'm just trying to sort of grapple with your argument. Should they have was it open for them to overturn Shubley, or was it not?
Yes, Justice. While the court is able to relook at cases, the appellant acknowledges the idea of a living tree doctrine and that it is open for courts to revisit. In the case of Shubley, the threshold for overturning a precedent has not been met. It has not been proven to be unworkable, and it has not been proven to be founded on eroded reasoning.
The Supreme Court seems to focus on that latter aspect of it. I mean, surely if a court is looking at a prior precedent and feels that it's been overtaken, then it's fair game for them to essentially revisit it, isn't it? Where's the error in that? Otherwise, what would be the point of any other subsequent case?
That is correct, Justice, that if it is proven to be eroded, the court is well within its means to overturn the precedent. However, in the case of Shubley, there is no underlying judicial erosion.
What year was Shubley? 1990?
That's correct, Justice.
I wasn't even in law school yet.
I wasn't even born.
Graduated by then.
That's right. Anyways, I digress.
The appellant acknowledges that this case comes from 1990. However, the principle of stare decisis doesn't have a specific line in the sand of what years the cases can be overturned. So by looking at the two factors of unworkability and erosion, it's understood that it has not met this high threshold. The courts have become more attentive to conditions of confinement, but this attention has not altered the regulatory character of inmate discipline. Judicial concern with prison conditions has not and should not collapse the distinction between criminal prosecution and administrative discipline.
But where the discipline it constitutes more something that looks more like a punishment, doesn't it matter that courts have become more attentive to the conditions of people's imprisonment, specifically any kind of segregation that's used punitively?
Yes, Justice, and your point brings me to the appellant's submission number 2, and I would like to turn the court to paragraph 27 of the appellant's factum. Speaking to this idea of punishment, the appellant acknowledges that while with loss of earned remission and segregation, there is a flavor of punishment, it does not rise to the threshold necessary for it to be considered a true penal consequence.
Well, the loss of earned remission results in an inmate serving a longer sentence, does it not?
Respectfully, Justice, the appellant's position is that it does not result in an extension of a sentence. It's simply a way for the correctional administration to administer a sentence that was already delivered in a sentencing hearing. There is no extension beyond the sentence that an inmate was given when they were at their sentencing hearing.
Yeah, go ahead.
Sorry, not beyond the actual sentence, but beyond how much of that sentence the inmate will serve.
Yes, Justice. However, the loss of remission and the delivery of remission to these inmates is an incentive program. It's a privilege that these inmates retain. When they arrive at the correctional facility, they are made well aware that remission is an incentive program that they can be given and it can be taken away depending on the behavior of the inmates during their time within the
So
correctional
what's the
facility.
incentive?
The incentive is to conform to order, safety, and control within the correctional facility.
Sorry, I wasn't clear. When you say remission, what do you envision remission permitting the inmate? What benefit do they get from a remission?
The remission allows for inmates to serve less time. However, it's less time of a sentence that they were delivered at their sentencing hearing.
Okay, less time, but they get to serve part of that in the community, I guess, right?
That is correct, Chief
They're-
Justice.
They're subject to far less, I guess, stringent restrictions. I think that you'd agree with me, that's fairly obvious. I guess what I'm struggling with is, how is it not some type of consequence if you in fact take away the remission days? It may be that when you look at it, it's not actually formally lengthening the sentence, but it kind of feels that way, doesn't it?
Chief Justice, it's the appellant's position that it is simply withholding of a reward that an inmate would receive for good behavior within their time spent at the correctional facility. I would like to draw the court's attention to the Queen and Goodwin, which is a case that occurred in 2015. And the court looked at whether or not there was a true penal consequence that flowed as a result of sanctions delivered for driving infractions. So the court looked at whether driving suspensions, vehicle impoundment, or costs that rise up to $4,000 constituted a true penal consequence. And the court determines that it did not. So while the severity of the sanction is something that the court should take into account, itself alone is not determinative of whether or not it is a true penal consequence.
But it's depriving an inmate of his liberty, is it not? Which is different than a consequence for driving while suspended.
That is correct, Justice. However, it's the appellant's position that this deprivation does not rise to the level of a true penal consequence, and it occurs within the limited sphere of activity of a correctional facility itself.
But it also impacts, for instance, their eligibility for parole. If they have a horrible record while serving their sentence, they may be less likely to receive early parole.
That is correct, Justice. However, it remains within the limited scope of the correctional facility itself. These sanctions don't come with the same societal stigma or consequences that flow from a criminal conviction. I would like to bring the court back to the first prong of the Wigglesworth test, which can be found at paragraph 23 of the appellant's factum. That's correct, Justice.
Which prong?
The criminal in nature prong. In reference to the criminal in nature prong, this court must assess two considerations. First, the objective of the legislation, and second, the process leading to the imposition of a sanction. The central purpose of Saskatchewan's proceedings are to maintain order, security, and safety within correctional facilities. It logically flows that the objective is administrative, aimed at ensuring compliance
While I understand your submission, you're arguing strenuously that, this is really administrative. The idea, when I think administrative, I think, a fine, loss of a driving privilege. I don't think of segregation or a potential change in the nature and condition of how you're serving a sentence in a penitentiary, for example, or even a reformatory, is at all administrative. So I'm focused on the consequence And to me, that's what does the heavy lifting here. Yeah, it may not resemble what we know of in terms of a criminal trial court, but that to me, I'm struggling with. The focus shouldn't be on that. It should be on the consequence.
Yes, Chief Justice. And the appellant maintains that the consequence of the sanctions that are delivered by Saskatchewan's regulatory services is that they are not true penal consequences. So I would like to bring
Can you give me an example of what would be a true penal consequence? I mean, if your submission's correct, then there's nothing that happens within the four corners of any of those institutions that would be a true penal consequence. Is that ultimately what the AG's position is?
Correct, Chief Justice. Ultimately, what the appellant brings forward is that, according to the court in Wigglesworth, in Martineau, and Gwindon, a true penal consequence will only arise from imprisonment that is of a magnitude that would appear to be imposed for the purpose of redressing a wrong done to society at large. In this specific case, it is about the maintenance of internal discipline within a limited sphere of activity within the correctional facility.
So if they did 100 days segregation, that was the rule, not 10 days, your answer would be the same?
Chief Justice,
You
may I?
can answer, yeah.
Thank you.
So 100 days.
Chief Justice, while there is a limit put on the amount of time that an inmate can spend in segregation as a result of the sanction delivered, it is at 10 days. However, if there is a point in time where they are given sanctions continuously, there are appropriate safeguards put in place that an inmate can appeal the decision, and there are appropriate safeguards that my co-counsel will address later in the Section 7 submissions. To conclude, Chief Justice, Justices, extending Section 11D to prison discipline undermines both institutional management and the integrity of the Charter itself. The Supreme Court's decision stretches functionalism beyond its limits. To hold otherwise would to blur the boundary between administrative and criminal proceedings. Subject to any further questions from the bench, those are my submissions, and my co-counsel will address the appellant's submissions regarding Section 7.
Thank you very much, Ms. McCullough.
Thank you.
That's the court's internal timer. All right, go. Yes, Ms. Zikic.
Good afternoon, Chief Justice, Justices. My name is Kayla Zikic, and I will be addressing the appellant's Section 7 submissions. Inmates are entitled to the same right to safety and security as any member of the broader public. And where safety is at risk, the state's obligation is clear. It owes a duty of protection to each and every individual within the walls of their correctional facilities. The appellant has two submissions. First, the Supreme Court erred in concluding that a heightened standard is required where there is an accusation of moral wrongdoing. Properly applying Justice Cote's interpretation, the appellant submits that Saskatchewan's Correctional Services regulations do not require a criminal standard of proof. Second, the appellant concedes that Section 7 is engaged. However, Saskatchewan's correctional regulations remain constitutional despite the balance of probability standard, as it is in accordance with the principles of fundamental justice. Turning to the first submission, which you may find at paragraph 45 of the appellant's factum. Chief Justice Wagner and the majority states that a heightened standard of proof is required where there is an accusation of moral wrongdoing and where there are severe liberty-depriving consequences. Here, the majority relies on a flawed interpretation of Pearson, particularly as it relates to this first element. The court in Pearson did not contemplate moral wrongdoing in a broad sense. Instead, the focus was specifically on criminal guilt. This is evident where the court situates Section 7's broad and flexible nature throughout the entirety of the criminal justice process, in highlighting instances where temporary deprivations of liberty are permissible, such as during an arrest. The court stated that proof beyond a reasonable doubt is not required at every stage of the criminal process, because not every stage requires a determination of guilt. It's clear that the court's intention was to draw a particular focus to criminal guilt as the point in which reasonableness standards are no longer permissible. Justice Cote states that what can rightly be gleaned from Pearson is that a heightened standard may be required where there is a determination of guilt or where there are severe liberty-depriving consequences akin to a criminal sentence.
But isn't there a finding of guilt in these disciplinary proceedings, as opposed to, say, a disciplinary proceeding taken against a medical doctor? Here there's a finding of wrongdoing, is there not?
Correct, Justice. There's a finding of wrongdoing. However, when we're looking at criminal guilt specifically, there is a particular function of criminal guilt. We are asking an individual to be held accountable for a wrong, for committing a crime that is in violation of the public interest. Here, the individual is simply held accountable to prison officials for violating a rule within the correctional services regulations.
But isn't it a goal of any type of punishment that's meted out, the protection of the public in criminal law, and in some aspects, rehabilitation, whatever that means, is in fact something that we trust that the institutions are trying to encourage. And viewed in that sense, isn't it sort of a wider, it's not just within the four corners, it actually does have a public interest element to it. It may not be sort of obvious at first, but when you think about it, maintaining order or ensuring that people are in fact punished for a whole variety of infractions, some more serious than others, is in fact more of a public, it's not entirely a private sort of analysis. I guess that's what.
A general deterrence effect.
Yeah.
Chief Justice, within the institution you're speaking to?
Yeah, well, within the institution, but broader speaking outside.
The implications don't carry the same weight as criminal guilt. When we are speaking about an individual violating the rules of an institution, that's a temporary sort of deterrent effect. The stigma or any potential adverse impact that it would have is not the same as when we are looking at a criminal sentence. So once the individual leaves...
Except it follows the inmate. It becomes part of the record of their time in the institution, and it follows the inmate. When an inmate has a finding of acts of misconduct, if we call it that. So it's not so temporary.
The appellant's position is that when the function, at the core of the function between the two, there is a fundamental difference. The difference being that we are asking an individual to be held accountable to broader society. And so when we are looking within the institution itself, that is a much smaller impact to the individual, unlike a criminal record that would carry with the individual for...
I hear what you're saying. I guess where I'm sort of struggling with that submission is it almost seems as if once you enter into the four walls, that sort of obligation to the broader community disappears, and you're basically in a totally different land. You really are, but at the end of the day, it's sort of artificial, I think, to sort of say, well, then the obligation to broader society, that distinction crystallizes. I guess that's what I'm struggling with.
Well,
I think
Chief-
the idea is that, yeah, I mean, we sentence people, you know, and we hope for the rehabilitation, but it's all based on public interest and broader obligations to society. It's not just within the prison population, this private contract between the inmate and the prison institution officials.
Well, Chief Justice, the administrators of the institution, that is their obligation, is to maintain that microcosm, the sphere which they are responsible for. That is what they are in control of. And so when we are looking at the function at its core, the administrators are holding that individual accountable to the rules so that they are able to maintain the orderliness, the safety, the security of everyone within the institution. Because they're not only responsible for the person who appears before a disciplinary panel who has been subject to a disciplinary hearing. They are also responsible for every other individual and the safety of every other individual within that institution. And so if we are to do a comparison to the broader society, then we would have to balance those interests. And when we're looking at the proceedings themselves, when we're balancing those interests, we look at whether or not the proceeding is fair. And we should not only be concerned about the rights of the individual that appears before the panel, but also looking to who else those administrators owe a duty of safety and security to.
Can I just ask you this on this? The second point from Pearson, that quote that you read is from Justice Cote. Why do you say that the severity of consequences of spending time in segregation isn't significant enough to create the kind of consequence that would require standard of proof beyond reasonable doubt?
For the second aspect, Pearson relies on the Queen and Gardner. In the Queen and Gardner, the emphasis was specifically as the sentencing phase as a crucial step in the criminal process. The focus there was that aggravating factors that are presented at the sentencing hearing, those have the actual effect of lengthening an individual sentence. And so to a previous point that the panel had asked, this does not serve to lengthen an individual sentence. What we are doing is merely shifting the form in which that individual is serving their original sentence.
But it's a pretty significant shift, right? So if you want to compare two things, if I commit a crime, the default is I go to jail and I'm not in segregation. So in other words, crime, penal consequence, general population, not in segregation. Here, consequence is I'm in segregation. So in other words, I'm getting a greater consequence in someone from the outside who actually is getting the original penal consequence. So why is segregation? Let's take earned remission off the table for a second. Why isn't segregation a significant enough a consequence to trigger this?
Well, Justice, if we're looking at the comparison which Chief Justice Wagner relies on, this focus in Gardner, we're talking about an individual who's serving a sentence that they would not otherwise have been serving. Here, the individual is serving out their original sentence. The difference being is whether or not they're serving the sentence in Gen Pop or if they had violated one of the rules within the correctional services regulations and they are then subject to disciplinary segregation. That initial deprivation of liberty coming from the broader public and being brought into the institution has far greater impact on the individual than simply moving them to a separate part of the facility.
But where their liberties are limited in the institution, does it not have a greater effect on the inmate to take away what little liberty they have, which is everything?
Well, Justice, to counter that point, I would also ask the court to pay specific attention to the other inmates in there as well, who, when we're balancing the interests of everybody involved, looking to the broader public, these inmates, they don't have the same ability to leave an environment that has potential risks to their safety. And so,
But what we're talking about is the standard of proof, right? We're not suggesting that the inmates who commit major disciplinary infractions just be permitted to not have any consequence. We're talking about the standard of proof at disciplinary proceedings. So there would still be consequences if it's proven beyond a reasonable doubt that they committed the infraction.
of course, Justice. But where we are raising the standard of proof, we are potentially limiting the administrator's ability to effectively ensure the safety and security of all of those that they are charged to care for within their facility. Accordingly,
What if there was an option where it was, is this unworkable? If segregation is being considered, in those circumstances, it's beyond a reasonable doubt. But if segregation isn't on the table, it's maybe, you know, there's no Grey Cup for you or no World Series Game 7. Balance of probabilities in that, is that an unworkable, is that too unworkable?
well, Chief Justice, what it comes down to is that the provinces have the ability to set whatever standard they do deem fit. And so it's simply just a matter that the provinces have chosen the balance of probability standard as a sufficient means to carry out their disciplinary hearings. And so long as
because it's easier to prove.
It's more effective in maintaining the environment that they are tasked to maintain. We run the risk of asking that it is not that it's easier to prove. It's simply that we are allowing the administrators to manage the facility in an effective and an efficient way where there is such a heightened risk to the safety of everybody involved, both the other inmates and staff. I'd like to move quickly to the appellant's second submission. Turning to the second submission, which may be found beginning at paragraph 60 of the appellant's factum. Section 7 allows for further deprivations of liberty so long as the process by which the state does so is in accordance with the principles of fundamental justice. It's the appellant's position that the procedural safeguards within the SCSR are sufficient to ensure fair adjudications when determined on a balance of probabilities. Where the implementation of a more stringent standard would undermine other objectives such as safety and security, the law allows for flexibility in the state's burden.
Is there any evidence that raising the standard would be problematic? I mean, there is a divide, right? There's provincial legislation, there are federal institutions that already have beyond a reasonable doubt as their standard. Where's the evidence that if we were to increase the standard, it becomes a problem? In other words, more procedural fairness for you, the sky's going to fall.
Justice, I'm mindful of my time. May I answer your question and conclude?
I have a bad habit of doing that.
It's merely reasonable inference, Justice, that if we were to ask that the administrators prove at a higher standard, that it would require more resources, it would further burden the system within the provincial system. In order to maintain confidence within our correctional system as a place for rehabilitation and reform, it's imperative that we allow administrators to make the decisions necessary for the safety and security of our correctional facilities. Because ultimately, some decisions are best left to the decision makers rather than a judiciary. Where discipline proceedings are neither criminal in nature nor impose true penal consequences, and where existing regimes abide by the principles of fundamental justice, neither Section 7 or 11D are infringed. For these reasons, we ask that this court overturn the Supreme Court decision and find that the SCSR is constitutional. Pending any further questions, these are the appellant's submissions.
Thank you very much.
Thank you, counsel.
Mr. Yordanoff?
Good afternoon, Chief Justice, Justices. My name is Jordan Yordanov, co-counsel for the respondent, the John Howard Society of Saskatchewan. The respondent's submissions on this appeal are about giving life to the substance of charter values for a part of the population that have already had their liberty deprived. When the state wishes to deprive the liberty of inmates beyond the initial stage of imprisonment, they must do so at the standard which satisfies the principles of fundamental justice. And that standard is proof, beyond a reasonable doubt, because no one falls outside the reaches of the Charter. The respondent therefore seeks to dismiss this appeal and uphold the Supreme Court of Canada's rulings that Section 68 of Saskatchewan's Correctional Services Regulations 2013 infringes upon Sections 11D and 7 of the Charter of Rights and Freedoms. I will make 3 submissions to address 11D. First, that the Supreme Court was entitled to review the Queen and Shubley. Second, that the inmate disciplinary proceedings are criminal in nature. And third, that segregation and the loss of earned remission are true penal consequences. Beginning at paragraph 7 of the respondent's factum, the respondent submits that the Supreme Court was entitled to review Shubley. The Supreme Court has given themselves non-exhaustive factors through the Queen and Bernard to guide the principled review of stare decisis in order to respect the value of precedent. Any one factor may be sufficient in itself, but the respondent addresses all 4 of charter engagement, the attenuation by more recent cases, the assurance of legal certainty, and the expansion of prisoners' rights to tip the scales towards a justified review of Shubley.
I mean, it would seem to me that the Supreme Court of Canada focused on the fact that the landscape has changed. What we like to say, you know, Shubley's been overtaken by the subsequent cases. Isn't there though a distinction here where? Am I right about this? Justice Cote found, well, actually, you're relying on pre-Shubley cases to say that there's been this development. Am I wrong about that, or is that the distinction that she draws?
That was indeed an issue at the Supreme Court, which spoke to a fault in the erosion argument.
Right.
One of the Bernard principles, which was used ultimately in the formation of the unworkability and erosion framework in the King and Kirkpatrick, by the concurring justices in the King and Kirkpatrick, was the attenuation by more recent cases. With respect to that aspect, the respondent draws upon not the habeas corpus trilogy, as memory serves, but one example being the Queen and Guindon, which clarifies the Wigglesworth test and orients it towards an effects-based analysis. Returning to the respondent's submission at paragraph 11, the scales are tipped towards this review because overturning precedent is a balance of certainty and correctness. The court must ask whether it is preferable to leave an unconstitutional decision for the sake of legal certainty. But as Lord Atkin of the Privy Council said in 1933, finality is good, but justice is better. If this court determines that Shubley is unconstitutional, then it must overturn the decision. The Constitution is the supreme law of Canada, and as held in Canada Attorney General and Bedford, stare decisis as a common law principle is subordinate to the Charter.
So what's changed?
One such example would certainly be, as noted, the Queen and Guindon. orienting the Wigglesworth analysis towards an effects-based rather than the formalism that was found in Wigglesworth itself and then Shubley. Turning to the liability component of Bernard, if overturning precedent were to expand the scope of criminal liability, then it would go against the Supreme Court's principled approach. But the same is not true in the opposite. When the law grows to be more favorable to the accused, when it acknowledges that inmates are not any lesser than other members of the public, the Supreme Court is entitled to act. And raising the standard of proof to beyond a reasonable doubt achieves precisely that, because it ensures that the deprivation of their residual liberties is carried out in accordance with the Charter. And with respect to the certainty principle, Shubley is nearly 4 decades old. Its judicial review is perfectly reasonable because the court has a positive duty to admit judicial error, even if that error is often repeated or long-standing. As contemplated in Ontario and Fraser, close proximity between decisions may attract scrutiny, but the need for that scrutiny is attenuated with the more time that passes. The certainty that arises from proximity between decisions is important, but only as a constellation of factors to be considered. And notwithstanding the respondent's position that correctness and the remaining Bernard factors outweighs the certainty interest, overturning Shubley would result in more, not less, legal certainty. There is no consistent standard of proof for inmate discipline across Canada. Federal courts already use the higher standard. Overturning Shubley would result in one predictable standard for inmate discipline in the country.
What do you envision happening then if we were to uphold the Supreme Court of Canada's decision on a practical level? So, you know, it's now beyond a reasonable doubt. It's not balance of probabilities. Your friend made the argument that now we've got to devote all these resources. We've got to sort of come up with the trappings of a criminal trial. Is that a fair submission in your view? Like, I'd like to know what, practically speaking, happens. Do we have superintendents, you know, studying what beyond a reasonable doubt means?
Chief Justice, raising the standard should not change the process meaningfully. It should not add any undue labor to prison administrations.
Wouldn't it be harder to prove beyond a reasonable doubt as opposed to on a balance of probabilities?
It would be, because the evidence itself should not change. The evidence within the prison ultimately is a discrete universe. There may be video surveillance or whatever else, but it is simply the quality at which that evidence is judged that will change. Therefore, not adding any additional labor to the efforts of the administration. Moving on to the second submission at paragraph 17. The Queen in Wigglesworth provides that proceedings which are criminal in nature are also public in nature, being intended to promote public order and welfare in a public sphere of activity. This submission puts forth that the interactions between prisons and inmates are public, and that the offenses which inmate discipline seeks to address the public welfare in order to satisfy the first prong of Wigglesworth.
Are they public, though? I mean, like, if I were to talk to my neighbor, I'm not sure my neighbor would know what goes on.
Or care.
Yeah. I mean, how can we say that it's a public function when no one even really knows what happens? I mean, you get maybe some media reports, but not a lot. So how do we say that it's not actually, as your friend points out, really a matter that is administratively dealt with in a private setting?
Chief Justice, prisons are creatures of statute. Inmate discipline is empowered by statute, and the jurisprudence with Mission Institution and Keela affirms that prison discipline is subject to judicial review because prison administrations are public bodies. And in the same light, inmates do not cease to be members of the public just because they've been incarcerated. Solosky and the Queen illustrates that they enjoy every right but for those limited by good law, simply as members of the public within a unique subsection.
But the public nature of it isn't going to change the onus of proof for more minor consequences, right?
No, Justice, because
Still public.
It is still public, but the minor offenses, because they don't tie into the second prong of Wigglesworth to the same extent, need not be litigated. And certainly today, because of the severity of segregation and the loss of earned remission, this is where it's most important to discuss and ensure that the correct standard be applied.
Let me ask you about the loss of earned remission. I would like to hear your position on your friend's point that it's really not getting a benefit. It's not the fact that you're actually getting more punishment, like segregation, which puts you in, it segregates you from other inmates. All earned remission is you're just doing more time inside, but it's part of your sentence. You're not getting a longer sentence. It's not changing the conditions of your actual incarceration. What do you say about that?
Bringing your attention to paragraph 31 of the respondent's factum. Through an effects-based analysis as oriented by the Queen and Guindon, while the legal sentence does not change with loss of earned remission, the custodial sentence does. Remission is earned pro rata or on a month-to-month basis, and at the moment which it is earned, the expectations of the inmates and the prison is that less time will be served in the custodial sentence. When remission is then taken away, that custodial sentence increases once more, which the respondent ultimately submits constitutes a true penal consequence. But remission has an additional component that arguably segregation may not. Segregation may have justifiably safety concerns, but the effect and purpose of remission is not tied to upholding safety in the same light. Lost remission deters, it denounces. The effect of lost remission may occur months after an offense was committed and is not rationally tied.
Isn't that the same as segregation? I mean, they're still having a hearing, right? I mean, we're not talking about segregation where you're separating two people, throwing them both in a cell and then getting them later. This is, segregation is happening after a hearing takes place, as you're advocating for proof beyond a reasonable doubt. I mean, remission is going to operate the same way in these circumstances, isn't it?
Justice, the practical effect of remission is counting backwards from the end of when the sentence would have been. Whereas segregation, the inmate more or less after these proceedings will be segregated. The inmate may not feel remission until potentially 6 months later, provincially speaking at least, and even more.
They'll know about it though.
They'll know about it.
And isn't that the important thing, is that they'll know about it, so it's affecting their behavior, because they know that if they're going to lose this in the future, they better stay with good behavior.
They will know about it, and it will affect their judgment, but the experience of having spent more days in prison will happen later, almost necessarily, than segregation as a punishment.
But the facts that we have suggest that the loss of earned remission constituted only 0.3% of the sanctions imposed. So it impacts a very, very small portion of that prison population.
Justice, yes, it does impact a small portion of of the prison population, but the respondent's position ultimately is that that percentage of the population also deserves the appropriate standard if there is a constitutional issue. And to close the book on lost remission, its denunciatory and deterrent effect, without the same safety considerations of something like segregation, lives in the spirit of the criminal code, because denunciation and deterrence are codified principles of sentencing within the code. Returning to the second submission, at paragraph 20 of the response factum. To summarize where we left off, inmates are a small part of the population. Inmates are a subsection of the population. We've established that these are public interactions, and the fact that inmates are a subsection of the public earns them greater charter scrutiny, not less, as shown in Sauvé in Canada. The state must be even more wary of violating the rights of inmates because of the vulnerabilities inherent to their position and because so few liberties do remain when one is incarcerated. And with respect to the public welfare component, the wrongdoings which segregation and lost remission punish are either analogous or identical to codified crimes. Offenses like assault are punished by these sanctions because they address codified wrongdoings within this microcosm of society. Despite the fact that criminal proceedings and inmate discipline can run concurrently, the criminal nature of major inmate discipline arises from the way in which prisons address the public welfare in their subsection of the public. May I beg the court's indulgence to conclude?
Yes.
Nearly 40 years after Shubley, the Supreme Court addressed a change in the legal and social landscape of Canada. They were entitled to align the law to charter values through a principled approach. Inmate disciplinary proceedings are criminal in nature because they address the public welfare for a subsection of the public, and segregation and loss of earned remission are true penal consequences because of their severe and punitive natures. Proof beyond a reasonable doubt is necessary because inmates do not deserve any less than the charter. If the charter does not protect the vulnerable, then it is locked up alongside them. This court must determine whether the branches of the charter should reach beyond prison bars. I rely on the respondent's factum for the balance on this issue. Subject to any further questions, these are my submissions.
Thank you very much.
Good catch.
Good afternoon, Chief Justice, Justices. My name is Macaire Tulloch, and I appear on the behalf of the respondent, John Howard Society, Saskatchewan. I will be making the Section 7 submission, reminding this court that if everyone has the right to liberty, that right to liberty applies to everyone, both those within and outside of correctional facilities, because no one falls outside of the protections of the Charter. Should this court uphold Shubley and determine that Section 11D of the Charter is not infringed by Section 68 of the regulations, the respondent submits that Section 68 of the regulations directly infringes Section 7 of the Charter. The respondent relies on the following submissions. First, the Section 7 test outlined by Chief Justice Wagner in the majority in the Supreme Court decision is the correct test. Secondly, Section 68 of the regulations constitutes a finding of moral wrongdoing. And finally, the disputed sanctions seek to punish incarcerated individuals with severe liberty-depriving consequences for moral wrongdoing. Beginning with my first submission, Chief Justice, Justices, I invite you to turn with me to paragraph 37 of the respondent's factum. Section 7 of the Charter holds that everyone has the right to life, liberty, and the security of the person, and the right not to be deprived thereof except in accordance with the principles of fundamental justice. The Supreme Court of Canada and John Howard Society, Saskatchewan and Saskatchewan, correctly relied on the Section 7 test that emerges from Pearson, from the Queen and Pearson, to determine where the presumption of innocence protections will require the proof beyond a reasonable doubt standard. That is where an individual is being accused of moral wrongdoing and where there is intent to punish said individual with severe liberty-depriving consequences for that moral wrongdoing. Our friends rely on Justice Cote in dissent, as Justice Cote highlights the examples of instances where there are severe liberty-depriving consequences. Her example is pretrial detention. And she says that if the test is to expand in accordance with the Supreme Court's decision, the majority decision surrounding Pearson, it would be far-reaching and problematic. The respondent, however, disagrees with this position, as Section 7 is not undermined, but instead it highlights the importance of the liberties, and within the context of our conversation, the residual liberties of those behind the prison walls.
I mean, isn't the concern, though, just from a practical perspective, that all of a sudden bail hearings are going to be subjected to this proof beyond a reasonable standard? Is that really not a live concern from your perspective?
From the respondent's perspective, no, Chief Justice.
Why not?
Because bail is preventive, whereas the disciplinary sanctions for which we are discussing are retributive. They serve.
But they're also preventative. I mean, the whole point of making sure that there's order in the institution is you want to prevent. There is a deterrence aspect to this, which is preventative, right? You want to send the message to other inmates: don't do this, otherwise, these are the consequences.
Well, considering the severity of the liberty-depriving consequences, for which I will discuss more particularly in my third submission, it is the respondent's position that the liberty interests of those behind prison walls don't somehow cease to exist.
No, but they're diminished. They're diminished.
They are diminished, Justice. However, the residual liberties that they have are to only be, they are only to be deprived of these residual liberties, provided that it is consistent with the principles of fundamental justice.
Yeah, but that's begging the question. Like, that's the whole issue is what does it mean to impose these sanctions in accordance with the principle of fundamental justice? So the submission that you and your colleague have made, which is, well, the charter applies within prison walls. No one's saying the charter doesn't apply to governmental action. The issue is this particular governmental action, does it require a particular process? So that's really the issue, is why does it require something that looks like a criminal trial?
Well, for the sake of contextualizing this conversation, Chief Justice, I invite you to turn with me to paragraph 60 of the respondent's factor.
60?
Paragraph 60. It cannot be lost on this court that the majority of individuals within Saskatchewan's correctional facilities are overwhelmingly those who have not yet received a trial. 55% of individuals, according to the statistic as found within paragraph 60, are, in the eyes of the law, presumptively innocent, legally innocent, and within that cohort it is the respondent's position that some of these individuals will be found to be morally innocent as well. And taking this court to paragraphs 58 and 59, not only do these sanctions directly engage the liberties of those who are presumptively innocent, but more particularly, this court must consider the fact that there is an overwhelming, that the individuals that are overwhelmingly make up the prison population within Saskatchewan's correctional facilities are overwhelmingly Indigenous. And the Supreme Court of Canada in the Queen and Gladue helps this court to understand that discrimination against inmates of Indigenous descent is rampant within penal institutions. And it is the respondent's position that while we are considering the test of Pearson to determine where there is a finding of moral wrongdoing and severe liberty-depriving consequences as a result of that moral wrongdoing, that this court must consider whose shoulders bear the weight of these sanctions, whose chest bears the blade of the knife of these sanctions. And it is the presumptively innocent more broadly, and Indigenous persons more particularly. Furthermore, Section 68...
Just following up on that point, if your paragraph speaks to the fact that they haven't even had their trial, right? I take you back to my earlier question. So is there a suggestion then that bail hearings, which put them there in the first place, right, under detention, should in fact have the same standard of beyond a reasonable doubt? I'm more, speaking for myself, concerned with the potential ramifications of suggesting that this argument, you'll be back here next week, Mr. Tulloch, on a case which deals with bail hearings. Your friends argue, or Justice Cote argues, well, there's a big distinction there, and is there a floodgates argument to be made, or is that just not realistic?
Again, Chief Justice, the issue at hand is not bail hearings, but the disciplinary sanctions administered by Saskatchewan's correctional facilities. And as stated previously to your question, it is our view that bail is preventative, whereas disciplinary sanctions for major disciplinary offenses are retributive. In bail, the presumption of innocence is still maintained. In disciplinary sanctions,
that element of, in your paragraph, that element of those individuals, the presumption of innocence is still, so your argument then basically, presumption of innocence at the bail hearing, presumption of innocence while you're awaiting trial should have the same standard, no? Or it comes down to retribution or prevention. That's as simple as that.
well, respectfully, Chief Justice, that's a question that we can explore before this court at another time. As set out by...
This time's now.
Well, again, Chief Justice, the focus of the respondent is on the nature of the disciplinary sanctions and the severe liberty depriving consequences. While bail is a very, very important aspect of the process for this court to consider, that is not the submission of the respondent at this time. As set out in the REBC Motor Vehicle Act, Section 7 applies to everyone, and it protects against punishments that violate the principles of fundamental justice. This is not overridden by competing social interests. The procedural safeguards of Section 7 constitutionally anchors the principles of fundamental justice. To put it differently, Chief Justice, Justices, what the Charter defines, the safeguards describe, contextualizing the way that liberty interests are to be upheld and the severe deprivations of liberty are to be subjected to constitutional scrutiny. Chief Justice Wagner clarified within the majority decision what Chief Justice Lemire determined in Pearson, that proceedings that fall outside of the criminal process may still possess features of accusation of moral wrongdoing and punishment with severe liberty depriving consequences for that moral wrongdoing. Furthermore, a quote by Professor Hamish Stewart may assist this court that many of the principles of fundamental justice, they were developed in criminal cases, but their application is not restricted to criminal cases. They apply whenever one of the three protected interests is engaged. From Pearson, we deduce that where there is a finding of guilt and severe liberty depriving sanctions imposed to account for this guilt, the beyond a reasonable doubt standard therefore applies. The respondent's position is that the test applied by Chief Justice Wagner and the majority therefore is the correct test. Turning now to my second submission, Chief Justice, Justices, which can be found at paragraph 45 of the respondent's factum. Section 68 of Saskatchewan's Correctional Services Regulations constitutes a state accusation of moral wrongdoing. The majority in the Supreme Court decision of John Howard Society, Saskatchewan and Saskatchewan drew a comparative link between criminal and civil contempt, expressing that what distinguishes the two is that criminal contempt rests on the element of public defiance, while civil focuses on coercion and the protection of private interests. Yet still, Chief Justice Wagner highlighted that within the context of inmate disciplinary proceedings, as that is the focus at hand, those seemingly attempting to achieve disciplinary objectives within a private context, they directly serve, in our view, a public function. They signal to inmates and to the larger public what is and what is not permissible. And inmates do not somehow cease.
How does the larger public know what isn't or is permissible if they never hear about it?
Well, Justice, by way of example, I'm from Toronto, and Windsor is quite literally a much smaller city than Toronto. But the interests of those within the context of Windsor it is still equally as public as a major city like Toronto. And narrowing that analogy into the context of what we are discussing, those behind the prison walls do not cease to be members of the larger public. In fact, it could be argued that the prison society is the public to these individuals, or is an aspect of the public to these individuals. And while our friends argue that the sanctions serve to protect the larger interests of other inmates, they serve a function that is akin to that which we find in the criminal process, as my co-counsel argued, to denounce and to deter. and to signal both to the individual and to others that such behaviors will not be permissible within the context of these facilities.
But, I mean, there's a distinction, isn't there? Though a criminal trial is a public trial. You have high-profile trials, you got low-profile trials. Low-profile trials are still held in the public. Anyone can go into the Windsor courtroom and watch, and I would encourage people to do that. I asked someone in Windsor, do you know what happened at Maplehurst in terms of an inmate being disciplined for not following an order? Chances are, unless it's a big significant event, they're not going to know about it. So I guess what I'm struggling with, you say there's a public element to this. I put it to your friends that, you know, yes, I think there is an argument that there is, but if they don't know about it, how is it sort of advance your argument?
Well, Chief Justice, if you were to ask an individual within Maplehurst of the ways in which these severe liberty depriving sanctions are administered and who has been subjected to them, I think the answer would be much different. And it is our position that.
So when you're talking about public, you're talking about the public within the walls of the institution as opposed to the greater public.
More particularly, yes, Justice. A finding of moral wrongdoing within the correctional context, specifically for major disciplinary offenses, it directly satisfies the first prong of Pearson.
Does it make a difference that there's no stigma attaching to it like there is in a criminal trial? Because with a criminal, if you're found guilty of a criminal offense, there's a stigma attached, greater depending on the offense. But these are disciplinary offenses. Is the same kind of stigma attached? And if there is no stigma, does that affect the fact that it's not really moral, it's not a moral wrongdoing that the kind that you're talking about here?
Respectfully, Justice, looking at the nature of the offenses found in section 54 and 55, Chief Justice, Justices, I noticed that my time is up. May I have a moment to
Yes, Mr. Tulloch.
complete this question? So, accusations of gang activity, of intoxicant possession, impairment, these are findings of moral wrongdoing that are akin to some of the findings of guilt that we might see within the criminal context. And while the stigma might not be to the same extent, considering the fact that many of the individuals that are subjected to the likelihood of these sanctions are still in the eyes of the law presumptively innocent, it cannot be lost on this court that such findings of moral wrongdoing and the punishment as a result thereof, I think Justice Caracia, you had asked our friends a question. These records, these findings of moral wrongdoing become a part of their record. And these play a role within the sentencing phase and other phases of the criminal process. So it is our view that these are serious considerations. Chief Justice, may I have a moment to conclude?
Yes.
Residual liberties are still liberties. The principles of fundamental justice do not somehow become inapplicable because someone is in prison. No one is beyond the parameters of the Constitution. And it is the respondent's position that Section 68 of the regulations directly infringes Section 11D. However, should this court uphold Shubley and find that it does not, it still directly infringes Section 7 of the Charter. In Section 7, it demands nothing less than the beyond a reasonable doubt standard. If guilt is to be found and a severe deprivation is to follow, the higher standard must therefore apply. Subject to any further questions, Chief Justice, Justices, these are my submissions. I rely on the respondent's factum for the balance.
Yes, thank you.
Thank you.
Any reply?
No, thank you, Chief Justice.
Good answer. All right, we're going to adjourn to see where we go from here, okay? Thank you very much for your helpful submissions and your excellent legal writing.
All rise if you are able. The Supreme Moot Court of Windsor is now recessed.
heartfelt round of applause for all of our mooters involved in this process today. Exceptional work, all of you. Now it is my pleasure to introduce Mr. David Zuber. David is the son of Honorable Justice Thomas Zuber, the founder of this moot. David completed his Bachelor of Law at Osgoode Hall Law School in 1989. He was certified by the Law Society of Ontario as a specialist in civil litigation in 1998. He is the youngest ever to receive this designation. He was also certified by the Law Society of Ontario as a specialist in environmental law. He's the only lawyer to hold both certifications. In 1999, David Zuber founded Zuber & Company LLP, a Toronto-based firm specializing in litigation. David's practice is primarily trial and appellate work with a focus on insurance law. Outside of the firm, David has contributed to a variety of legal and insurance publications and has co-authored a textbook for high school law classes across Canada. Moreover, he has been a member of many committees, including but not limited to Civility and Justice System, the Advocate Society, the Defense Research Institute, and was formerly Treasurer for the Canadian Defense Lawyers Association. He's an active member of the Federation of Defense and Corporate Counsel, an organization comprised of leaders in the insurance and corporate defense bar. We're so grateful to have David and his family, friends, and associates in attendance with us tonight, and I'd like to extend a warm welcome to David Zuber.
Well, good evening, everybody, and I'm very honored to be here. And I want to extend a big thank you to Dean Vatty, who and the Zuber Moot Committee. We had a couple of meetings prior to this. It always seems to be a lot of fun. This is an event that me personally, as well as the firm, is sort of proud to be involved in. We don't often get to be involved as lawyers in things that celebrate the art of advocacy, the discipline of preparation, and the pursuit of justice. And you'll find, as practicing lawyers, it'll often be more about billable hours, getting the clients' phone calls answered and that type of thing. So enjoy this. The comments I wanted to make, and just some short remarks, and I'm sure that there's not many people in this room who would have known my father. But the University of Windsor Law School named the moot after him, not just because of his accomplishments as both a lawyer and a judge. It was really a reflection of the man that he was, his values, his humility, his integrity, and this belief that the law at its core is a service to others. I think a lot of people, particularly when I started as a lawyer, I think assumed, that my father must have come from money or prestige or something, when in fact nothing could have been further from the truth. Born in Kitchener, his parents separated when he was very young. So he ended up moving quite frequently because his mother couldn't look after him. And he sort of, as he describes it, he went from one relative to the other who could actually look after him. Eventually, his mother got a job in Windsor, which he describes as sort of a real watershed moment, because he went to Assumption College. He did some testing for which it then determined that he might be pretty good at law. So he went to Osgoode Hall Law School and graduated in 1951. And at the time, Osgoode was the only law school in Ontario. So, as he said, it would have been a lot easier to go across the river and be an engineer because he could have stayed in Windsor, but he had to go to Toronto to do law school. He came back and he practiced 17 years as a lawyer in Windsor. And in that 17 years, he really had a remarkable career as a lawyer. He ended up, by the time he was finished, he was the federal prosecutor in Windsor. He defended or acted on behalf of Chrysler, major insurance companies, all the municipalities. And he often would tell stories of that, and as a lawyer, I remember thinking, like, God, you got to be kidding. Within his first 6 months of being a lawyer in Windsor, that he had defended a murder case successfully, had done a civil jury trial on behalf of an insurance company on occupiers' liability, and then it started. And he liked it. He very much enjoyed the practice of law, but he decided in 1968 that he wanted to try something different, and he did two things, which of course changed things quite dramatically. He accepted an appointment as being a county court judge, but he also accepted, and there was some overlap, and there was the debate, could he do both? He accepted a full-time position as a professor at the newly formed Windsor Law School in 1968. So he ended up giving the very first lecture at the University of Windsor Law School. The reason being is his classes, he said, the only way I can do this is I have to be in court by 10. I'll give the lectures at 8 o'clock in the morning. So come September, it was an 8 o'clock September lecture for which he gave. So that's how he ended up giving the first lecture. Of course, on the county court, he was on the county court from 1968 to 1972. At that time, to be a Superior Court judge, you had to live in the Toronto area. So he got appointed to the Supreme Court of Ontario, and that's when we as a family, we moved to Mississauga. But he kept the ties, and they named the Zuber Moot after him. He was appointed to the Court of Appeal in 1975. And then then the Attorney General Ian Scott appointed him to look into the court system in Ontario, and that's 1987. One of the things that he did, and I always sort of suspected that he had an ulterior motive, because he organized the courts. It was no longer going to be centraled out of Toronto, but it was a regional based. And so everybody in this room will practice in a law for which it's, Southwestern Ontario is a judicial region, there's Metro, there's Central East, and so on. So he did that with a number of other reforms, but he came back to Windsor as the very first regional senior judge for Southwestern Ontario, so they moved back. And they left me there, but they moved back. And he's the only judge to have ever done that, to have gone from the Court of Appeal back to being a trial judge. But he did that because that was sort of where his heart was. He very much liked the trial work. He'd been on the Court of Appeal almost 20 years, but he was still interested. He was very much the judge who wanted to hear the cases, wanted to hear the arguments. He encouraged the young advocates to, your case better than the judges. Don't be afraid to go argue your case, to believe in the process. He remained on the bench till he was 75, and then even then he went back and he was back to practicing law. He stayed in Windsor. He frequently had lawyers who would consult him, and he almost never charged anything for it. And the lawyers tell me when he did charge, he would grossly undercharge. But he would look at factums. He was very much a believer in this is the process, this is the skill. He, since I've been a lawyer, I run across a lot of judges who will tell me stories about, my father, to say, oh, and some of them, my dad had this somewhat dry sense of humor, but it was always it was Justice Brown of the Court of Appeal, who's just retired this year, told me, he would talk at a lot of these judges' conferences, and it was he was a judge who had been both on the Court of Appeal as a trial judge and then back. So he gave a talk on the one that Justice Brown was saying. It was called the title of it was "Don't Worry About It," and the whole talk was, on any individual evidentiary ruling, you had a 50-50 chance of getting it right. And even if you got it wrong, the Court of Appeal only allows the appeal 25% of the time. And on any given one, even on those, it still has to be a miscarriage of justice, so to send it back. So to say the odds of getting overruled on any case, on any particular evidentiary ruling, was fairly small. But the point, Justice Brown said, everybody was in hysterics laughing because it highlighted the point that you just needed to make, as a judge, you needed to make the decision. And that was sort of one of the many stories that I sort of heard. One of the things that there's a real connection between what he believed in what we're seeing here tonight. He was very much believed in the educating of the young advocates, not only but in the technical skill, but also in the character. He's always used to say advocacy is a form of respect. You should always assume that your opponent on the other side has something worth listening to. And one of the things, as I'm sitting here, and I would think that he would have admired the people who participated tonight on the dedication, your courage to test your ideas. And as you see, and this happens, I'll tell you, as a lawyer, you often get judges who will give you a hard time, but it doesn't mean that they don't like you. They often, you'll see that you'll get the hardest time, and then you end up winning the case because the judges want to test the ideas. What's the response to these arguments? So, you'll often see that. Don't take that as I think that judge had it out for me, because they don't. They just want to. They come from the position that they want to come to the right decision as well. But as we saw here tonight, if you're prepared, you answer those questions. Just in closing, it's many years since my father passed, unfortunately, in this year, but at 90, just shy of his 98th birthday, so full life. But he hasn't been a judge since he was 75, so it's been a while. But his influence is an impact. It's so important and proud for me to see that that's continued on. And again, if you knew my father, he very much didn't believe that justice had to be shouted. There was integrity in the quiet consistency, and that when he practiced, it was with humility and empathy, and he believed it was a true calling. The last thing that I was going to say is that he would have been, as I say, very proud of everybody here, that you're interested in it. You would have been proud of the participants. And I would just say to the people who competed, whatever happens, I think all of you did a terrific job.
Thank you very much for your words, David. We will proceed with some of our preliminary round awards now. So this year, we are very honored to introduce a brand new distinction, the Honorable Justice Thomas G. Zuber Award, created in memory of the late Justice Zuber. His legacy reflects a lifelong dedication to fairness, compassion, and the advancement of justice, which are all principles that continue to guide this competition and our broader legal community. The recipients of this award are two preliminary round mooters who most closely embodied the qualities that defined Justice Zuber's approach to the law. In selecting the award winners, we assessed integrity, reflected through honesty, adherence to the Zuber Moot rules, and the willingness to make principled concessions. We also considered professionalism, demonstrated through strong preparation and clarity of advocacy. Practical wisdom was evaluated by examining the realism and sound judgment shown throughout the moot process. But most importantly, we looked for an unwavering commitment to justice, evidenced by a thoughtful and rigorous access to justice lens and expressed through originality and creativity in both written and oral advocacy. This award recognizes not only skill in advocacy, but also the values, discipline, and ethical foundation that Justice Zuber exemplified throughout his career and life. So it is my privilege to announce that the inaugural Honorable Justice Thomas G. Zuber Award is presented to both Omer Malik and Kate Lloyd.
We would like to take a moment to recognize the exceptional work demonstrated by all participants during the preliminary rounds. The quality of both the oral and written submissions throughout this competition has been truly remarkable. The committee is proud to announce the two honorable mention oralists who have displayed clarity, confidence, and persuasiveness when delivering their oral submissions. Please join us in congratulating Kate Sirkirkis and Ria Patel.
Each team participating in the preliminary rounds submits a factum for the competition, and this year's submissions exceptionally showcased the strengths of Windsor Law's written advocacy. The committee is pleased to announce this year's best factum, awarded to two students whose attention to detail and coherent legal arguments were truly outstanding. Please join us in congratulating Salvatore Salerno and Remo Tramontozzi. The judges are now prepared to return to the courtroom for the conclusion of this afternoon's final round competition.
Okay, well, thank you very much for your submissions. We were able to come to a decision on the case for reasons that will never come later. We would add that we are in substantial agreement with the reasons of Chief Justice Wagner of the Supreme Court of Canada, and therefore we would dismiss the appeal, notwithstanding the appellant's very forceful submissions. You win. I see Professor Tanovich sitting behind you. That's not often uttered in the Court of Appeal. We are very grateful to have been given the privilege of being the judges in Windsor for the Zuber Moot, especially in honor of Justice Zuber. I know David, Lori, and Tim, you're here, and the rest of the family. Again, let me extend our sympathies for the loss. Justice Zuber is a big part of the history of the Court of Appeal for Ontario. I never had the opportunity to appear in front of Justice Zuber, but I know lots about him, and talking to some of my older sort of colleagues, they've given me an idea of what an outstanding jurist he was, but more importantly, what a wonderful colleague he was, and I'm sad that I never got to actually sit with him. But it is an important legacy to have this moot, the Zuber Moot, continue, and it's such a wonderful experience. So on behalf of the panel, we are very grateful that we were invited to participate in this moot. We're going to give you some general remarks about appellate advocacy. I just want to say that that was just outstanding, all four of you.
All of you deserve a very big round of applause.
So your families, if they're here, your professors, your coaches, your teachers, maybe some of your classmates that helped you get to this point, I think should be very proud, but also I can't imagine arguing a case with this many people in the courtroom. Now, it's not going to happen in real life. There might be two people there, but
sometimes there are a lot.
Sometimes, but this is clearly a huge audience, and to do this in an auditorium like this, in a case like this, is really an outstanding achievement. And I will ask Justice Caracia and then Justice Ramon, and then I'll wrap up with some general remarks about advocacy, and then we'll announce our two top oralists. So, Justice Caracia.
Thank you. I can say I did appear before Justice Zuber when he came back to Windsor and sat in the Superior Court of Justice before or after the Ontario Court of Appeal. And if you think we asked you a lot of questions, that was nothing compared to appearing in front of Justice Zuber. So I did have the honor of appearing in front of him. One word that came to mind when I listened to all four of you is poised. You were all so poised for being in this, in this environment, which is very unnatural and where you're being watched by everybody. So I thought all of you did such an excellent job of trying to put your positions forward because we tend to ask a lot of questions. So I know that's difficult, but you also responded very well to the questions. So when you're advocating at the trial setting as opposed to the Court of Appeal, you may get the same thing. You may get a lot of questions. You may get a judge who's asking you lots of questions as you go, as opposed to saving the questions up for the end. So I thought each of you did a very good job of incorporating the questions in and getting back to making your points. But don't forget that sometimes you may want to stop where you're at and get on to your next point because the time runs out. the time runs out. But I thought all of you did such an excellent job. Very proud of you.
Justice Ramon?
Yeah, I agree with all of those comments, and I thought you all did very, very well. And just to add to what Justice Carrozza was saying, not only are you in front of a big group here, these are your peers. I would much rather appear in court in front of judges than appear in a room full of my peers in front of judges as well. It's a lot harder. I know when I did anything in both in law school and even as a lawyer, when we do any kind of, sometimes we had to moot a problem before we went to court. It was always more difficult doing anything, any kind of training course, anything in front of your peers. Yeah, it's a lot different. And having this many people, it's you all demonstrated grace under pressure for sure. I'm going to make just two general comments about advocacy, not necessarily related to what, because we're going to give you individual comments afterwards, so I'm not going to say anything necessarily about what you did here. The one thing that I will sound like a broken record about always in any kind of advocacy, written, oral, trial, or appeal, is try to always speak in plain language in court. It's one of the most important skills you can get. When you get to law school, everybody's using all these legal terms. You start to, throw around Latin. Any of you who are doing joint program know the Americans love Latin. They say all kinds of stuff in Latin. You have no idea what is sua sponte and all this stuff, and they're stipulating all the time. No one talks like that in real life. So what I'd impress upon you, though, is when you go into a courtroom, your environment affects the way you think. And if you think courtroom formal, you're always going to speak differently when you go into court. Don't do that. We all know you've had however many years of post-secondary education. You don't have to prove it to us. If you speak it actually at a plain language level, even for a judge alone, even for somebody who's well-educated, it's actually easier for us to listen. There's studies about this. If you speak to us at a grade 10 level, we can pay attention longer. And there's nothing wrong with that. In writing also as well. If you can write at a level that people can understand who don't necessarily have your education, it's easier for them to take in the information. So always keep that in mind and train yourself to not speak like a lawyer. I know that's a weird thing to say to people in law school, but don't talk like a lawyer, even when you're in court. The judge will still understand you. No judge has ever stopped a lawyer and said, "I'm sorry, you're speaking way too simply for me." No one's ever said that. Doesn't happen. It's usually the opposite. I have lawyers that use words sometimes I have no clue what they mean. I have an English degree, so don't do that. Second point, Justice Carrozza already touched on it, so I'm not going to say much about it. In the Court of Appeal, anytime you're doing appeals, be mindful of your time. Time is your enemy in the Court of Appeal, as you all probably felt. I know you all thought that time went by way too quickly, and it did. So when you're in our court, we enforce those time limits very, very rigidly. And we don't always give people more time. Sometimes people will say, "Can I have," they use up all their time, and then they get to reply. They're supposed to reserve time. They'll ask, "Can I have just 5 minutes for reply?" You get 2, and that's it. And you've used up your time. So be very mindful of time, and think about, even before you go into the appeal, one of the things you want to think about is, if I get a lot of questions like you got today, what do I need to get out? What do I really need to tell the court, and what can I leave to my factum? Go in. That's part of preparing for an appeal. Make sure you know exactly what you need to get out, because if you get bogged down in questions, you'll know exactly where to move on.
Yeah, I echo my colleagues' comments, both Justice Carrozza and Justice Ramon. Let me start with the first years, because I think you're here because you're supposed to be here, right? It's mandatory? Okay.
That's why we have such a big audience.
Well, believe it or not, I think that is actually a really good thing. So if you're thinking about mooting, it was important that you be here to see exactly what it's all about. When I was in your shoes in first year, I mooted, and I basically flamed out, right? I mean, I froze, and I never wanted to moot again after that. It's ironic that I'm actually now doing mooting for a living, really. But, so I hope that those of you in first year have gotten the bug, and speak to your colleagues here who just got up, and we tried to make this, and in fact, it was pretty realistic to what happens in our court, just so you know. And so, please, I'd encourage you to moot. It's actually a fantastic experience. You've got one of the greatest mooting programs here. We see Windsor in the Gales, we see Windsor in different moots, and take advantage of where you're at and the outstanding people that run your mooting programs. About appellate advocacy, it's different. It's different than trial advocacy. To a certain extent, good appellate advocacy, and I don't know if you felt this, the four of you, is really having a conversation with each of us. What's bothering me? What's troubling? What I'm struggling with? Help me out on that. And really, most of you got out of your notes, tried to anchor us back into your factum, but I could tell you were making a sincere effort to try to help us in that conversation. And so really good appellate advocacy is just a conversation between the advocate and the judges on the court. The second thing that I would say is, in our court, trust is really important. Once we learn to trust the advocate, and we get advocates who are frequent flyers in the Court of Appeal, but they're trustworthy and we trust them, they go in with an aura of, even if their appeal is a real loser, it makes us think, just by virtue of the fact that I can trust that person. How do you develop that trust? Well, obviously experience is going to help, but I think at an early stage, organization, knowing the record cold, knowing the record better than anyone else, and you all exhibited that, that's what establishes trust. And being reasonable, right? Don't oversell. If there's a question put to you that requires sort of an answer, yes, you're obviously there arguing for a side, but often, if you can be reasonable and not oversell your case, then trust is important. The third thing is, the second thing about appellate advocacy is, sometimes it's not about what's in the cases. Like, I mean, I know you know those cases off by heart. Like, we could tell, right? You were into them. But sometimes, how do we apply them in real life? That's what appellate courts often are very concerned. So think about, how does this apply on the ground? Forget Wigglesworth, forget the test. Here's why we win, because the sky isn't going to fall, and it's important, right? I mean, sometimes those submissions intertwined with your legal submissions are actually the most important. And finally, I would say written advocacy. I mean, all advocacy. We gave a talk earlier to a couple of clubs, and we said communication. It's all about communication. Oral advocacy and written advocacy. And in the appellate setting, your first opportunity to make an impression is your written advocacy, right? Because we go in, we've read your written work, and that's our first impression of you. And so don't underestimate the importance of written advocacy, because those who really write well, it makes up for the time limits that you're really under, because you're not going to be able to get through your argument, especially with a hot bench. When I mean hot, we mean asking a lot of questions. That's what I mean by hot. And I would say this, I mean, all four of you have a bright future should you want to go into it in terms of litigation. Each of you, I think, were very confident very poised. And you know, you really, as I say, I felt like, to a certain extent, we were sitting on a real live appeal. That's exactly what it would look like in terms of the bench engaging with you. So, very well done. We will have more individual critique to give you privately. We'll do that. But it was an honor and a privilege to have you moot in front of us. Okay. So I'm going to announce the top two oralists, but you know, it was a very tough decision because you were all very good, but we were told we had to make a decision, which is what we were directed to do. So the top two oralists, in no order, are Taylor McAuliffe and Macaire Tulloch. Is that it?
All right, so that just about concludes us for the night. I want to say a huge thank you to this bench. You guys were terrific. Justice Carosa, thank you so much. We have a few tokens of our appreciation for you here. And then there's a few other people I want to thank quickly before we send you all on your way. Dean Rimbadi, thank you so much for all of the support that we got from the school. Melanie Monami, Jessica Reno, Stephanie Biazzi, Professors Curis and Little Kwan back there who did an incredible amount for us. David Zuber and the whole Zuber family, thank you for being with us. All of the Law 1 volunteers who helped us put this together. It was incredible how you guys all came together both in the preliminary round and tonight. And to all of those who participated in our preliminary round, this was the biggest year yet, as we've said. It was fantastic organizing this event. We really hope you enjoyed it all, and have a good night.
We do have one more special announcement to make tonight. We want to, on behalf of all of Windsor Law, thank the 2025 Zuber Committee for doing such an amazing job. If you could all come join us at the front, we do have gifts on behalf of Professor Curis and Professor Littlequan for all of you for your amazing work on putting on this event and the entire moot competition. So thank you.
Do the photo? Right here?
Or
Yeah.
outside here?
I think we sit down and then the mooters go in the back. Yeah. Do you want to tell the mooters? Yeah.